Good morning. I'm going to talk about a recent case in the High Court, which has been heard, but which we are still awaiting judgment. So we don't know exactly what the court is going to say about this as yet. The case examined the Secretary of State's policy regarding housing trans women within the female prison estate. Claimant, a woman who is a now former prisoner, was assaulted by a trans woman with whom she was detained. She's bringing the case arguing that the policy is unlawful as it creates a discriminatory impact on women and is contrary to the Equality Act. In the UK, male and female prisoners are housed separately. This is in accordance with international standards such as the UN minimum standards for the treatment of prisoners. This rule is though disregarded when it comes to trans women. All trans women may request and be granted placement in the female estate. We are unaware, perhaps for unsurprising reasons, of any request for trans men to be housed within the male estate. Trans women with a gender recognition certificate, there is a presumption that they will be housed in women's prisons in all but exceptional circumstances. Trans women without a gender recognition certificate are placed in the female estate, in theory, subject to risk assessments, but in a practice, it appears that there is little to no relevant consideration of the risks to the female detainees. Transgender people have a different status in law depending on whether or not they have been issued with a gender recognition certificate. It's only possession of a gender recognition certificate that conveys the legal status of having your target sex, that is the sex that you have acquired, as the wording of the Act says, through the process of transition to that opposite, to the sex that you are, whose gender you are adopting. Otherwise, your birth sex prevails. A gender recognition certificate is issued by a panel. It requires a diagnosis of gender dysphoria and evidence of having lived in the acquired gender for at least 2 years. Surgery or hormonal treatment is not required. Once issued, Section 9 of the Gender Recognition Act requires that they be treated in law as their acquired sex for all purposes, albeit that may be qualified by any other enactment. And we are focusing today on another enactment, that is the Equality Act, and the exceptions that are provided therein, referred to generally as the sex exceptions. The most relevant sex exceptions relate to single-sex services and single-sex accommodation. Schedule 3, paragraph 28 says, and I summarise briefly, that a person may lawfully discriminate against a trans woman with gender recognition certificates if the conduct in question is a proportionate means of achieving a legitimate aim, and in order to provide separate services for persons of each sex. Schedule 23, paragraph 3 says similarly, a person may lawfully discriminate if the accommodation is managed in a way which is fair as possible to both men and women, and where, in the case of gender reassignment, the conduct in question is a proportionate means of achieving a legitimate aim. And that phrase, the proportionate means of achieving a legitimate aim, is absolutely key to the way that this Act is interpreted. Also of relevance to this litigation is the public sector equality duty, known as PSED. And this is important because it creates a duty for public authorities to have due regard to such factors as eliminating discrimination, positively fostering equality of opportunity, and good relations between people with differing protected characteristics. Authorities should carry out properly evidenced examinations of competing rights and interests before formulating law or policy. No one protected characteristic should have precedence over any other. And that is important because, of course, sex in itself is a protected characteristic. The Secretary of State and Ministry of Justice have taken some steps to try and deal with the problem of housing trans women who wish to be housed within the female estate. They have created a specific wing in HMP Downview, which is the first specialised prison unit for trans women in the UK. It is used specifically to house trans women who have a gender recognition certificate. But as the policy itself says, this is used only for trans women who have been assessed as presenting a high risk of harm to other women in custody and exhibiting behaviour or predicted behaviour through risk assessment that is dangerous, disruptive, and/or particularly challenging where the risk cannot safely be managed on normal location within the woman's estate. Now, that sounds like it's a good thing, house these trans women separately, but they are not housed entirely separately. The policy continues to say that trans women housed on this wing have communal access with other female inmates to facilities for recreation, faith activities, education, employment, and behaviour programmes. Turning then back to this case in the High Court on judicial review, the claimant, FDJ, was a victim of male violence before she was sentenced to imprisonment in 2016. Whilst she was detained at HMP Bronzefield, she was held with a trans woman called Jessica Winfield. Winfield is understood to hold a gender recognition certificate, but that has not had any genital surgery, so is biological intact male. Winfield was also sentenced to imprisonment for rape of a female. Winfield assaulted FDJ, groping her breasts in the prison toilets. Other female prisoners detained at the same time with Winfield also alleged that Winfield assaulted them. Shortly after making her complaint of the assault, FDJ was moved to other prisons, but eventually she ended up, towards the end of her sentence, being held in HMP Downview. And she learned that Winfield was also held there. And the distress that was caused to her, to being learned that she was once again detained, incarcerated with her assailant, was significant. The legal challenge that's been brought has been brought on three grounds. Firstly, the policy of housing transgender prisoners in the female estate that matches their gender identity rather than their birth sex indirectly discriminates against women and is contrary to women's human rights. And this is because there is a greater risk of harm to female detainees due to physiological differences, and that women prisoners are likely to have experienced abuse before imprisonment. Over half of female detainees have been subject to domestic abuse and 53% to childhood abuse. They carry trauma, which is triggered in some circumstances by being placed in circumstances they can't control with male-bodied people. The second ground of challenge is that policies that govern the housing of transgender inmates are unlawful as they fail to consider the single-sex exceptions such as are set out in the Equality Act. The test for excluding trans women from the female estate is misstated as requiring exceptional circumstances, whereas the Equality Act, as in the slides that we saw earlier, requires only proportionality, that is a balancing of the interests between the two affected parties. The third ground of challenge is that no adequate public sector equality duty was undertaken. Firstly, insufficient data is collected about the number of transgender people within the prison estate. The Ministry of Justice does hold numbers about the number of trans women who don't have a gender recognition certificate, but that has no numbers as to the number of trans women detainees who have been issued with a gender recognition certificate, because they are treated within the numbers of female prisoners. There is no proper analysis of the offences for which trans women are serving their sentence. They did not expressly consider the number of incarcerated women who have experienced male violence and who would suffer particular detriment from being confined with an abusive male, again, that's linking back to the duty to balance interests. There's been no examination of the impact on women for this policy, and there has been no assessment of the operation of the policy in the 18 months since its introduction. Our concern is that a policy which permits a trans woman sex offender the opportunity to commit further offences whilst incarcerated, and then goes on to fail to protect the victim of that offence from being imprisoned with them again, should create cause for significant concern. Thank you.